It is sufficient for the Crown to produce evidence by means of which such a high degree of probability is raised that the ordinary reasonable man, after mature consideration, comes to the conclusion that there exists no reasonable doubt that an accused committed the crime charged. He must, in other words, be morally certain of the guilt of the accused. An accused claim to the benefit of doubt, when it may be said to exist, must not be derived from speculation, but must rest upon a reasonable and solid foundation, created either by positive evidence or gathered from reasonable inferences, which are not in conflict with or outweighed by the proved facts of the case. Moreover, if an accused deliberately takes the risk of giving false evidence in the hope of being convicted of a less serious crime or even, perchance, escaping conviction altogether, and his evidence is declared to be false and irreconcilable with the proved facts, a court will, in suitable cases, be fully justified in rejecting an argument that, notwithstanding that the accused did not avail himself of the opportunity to mitigate the gravity of the offence, he should nevertheless receive the same benefits if he had done so. In his confession, the accused says, I pointed the firearm at her and said to her, this is the end. I am going to shoot you and then myself. Nothing can be more clear. Significantly, to add it to this, is that he managed to pull the firearm out of her hands, even on his own version. So clearly, he had the necessary control. Before I deal with the form of intention, I must just briefly deal with the exculpatory portions contained in the accused's statement, Exhibit A, the confession he made to the magistrate, where he inter alia referred to the fact that the firearm just went off and that he did not pull the trigger. Now, our law recognize the so-called rule, the Valasha rule, which simply means that if the state proves a statement of which a portion is exculpatory, it can be argued that the state is bound by that, and it cannot only choose those portions which incriminates the accused. However, a trial court is entitled to reject an exculpatory portion of a statement attributed to an accused while accepting the inculpatory portions thereof after a proper consideration of the evidence as a whole. And in this regard, I refer to the cases of State versus Causa, 1982, Volume 3, South African Law Reports, 1019. It's appellate division decision at 1039 next to the letter A. State versus Yelani, Y-E-L-A-N-I, 1989-2, South African Law Reports, 43, Appellate Division, at pages 50, next to the letters A to D, and then, of course, the locus classicus, State versus Valacha and another, 1945, Appellate Division, 826, at pages 835 and 837. I therefore find that on the evidence presented before this court, the form of intention can only be that of dolus directus. The next question then for the state to deal with, for the court to deal with, is whether this murder was premeditated or planned, as the state charged the accused with murder read with the provisions of Section 51(1) of Act 105 of 1997. In this regard, I have regard to the following facts in evidence. Firstly, the firearm was stolen on the 24th of April, some 2 weeks before the murder on the 8th of May 2018. It is clear that the accused procured the firearm to kill her. That is the only inference the court can make once it has decided that the meetings of 24 April and the supposed meeting of the 8th of May and the reasons therefore did not occur. There is no other inference the court can make. It is clear on the evidence that the accused waited for the deceased at her work. He did not make his presence known to her at all. He followed her for some distance. In his own words, I was lagging behind, in, as he says, to see where she was living. Once he had entered the house, it is clear from all the evidence, not only was he armed, but he already had the firearm in his hand. According to the lady whom he ran into, who showed him the house, she explained that he had the firearm in his right hand, pointing to the ground. Thereafter, this witness fled the scene, and soon thereafter a shot went off. But according to her, he pushed the deceased and said to her that this is the person I want. So from the ballistic evidence, it is clear that not only was the firearm cocked, it must have had a round in the chamber. There is no other inference. There is no other inference from the evidence of the accused. Only the deceased was there. He was after her and no one else. He pressed the trigger, and in this regard the evidence must be recalled of the ballistic expert who said, 1, you had to pull back the slide, 2, you had to activate the safety the safety catch, and 3, then you actually had to pull the trigger. From the evidence, he shot her from behind. According to the evidence of the doctor, the shot went downwards and to the right. This is reconcilable with the evidence that he was slightly taller at 1.6 meter vis-a-vis her height of 1.65 meters. According to his own version, in his own words in the confession, he said, I pointed the firearm at her and said, this is the end. I am going to shoot you. I pause here to state that I emphasize that under cross-examination, he said that is in fact his statement. I also take into account that on the accused's own version under cross-examination, he was jealous. All of the above was indicative of planning, as well as his actions afterwards. He picked up the rounds, the live rounds, which were still lying on the ground, so the events could not unfold so quickly as he'd like the court to believe. After the shooting, he walked away from the scene as if nothing happened, with the firearm hidden under his hat, I think he said his hat, and he took a taxi to his mother's house. At his mother's house, he took this firearm and he hid it under the bed. On his own version, he thereafter reloaded this firearm, if that is to be believed. It is clear from the evidence that although it was mooted that he would hand himself over, he wasn't really interested in that. In the final result, I then find that it is clear that the accused should be convicted in respect of count 3 of murder, read with the provisions of section 51(1) of Act 105 of 1997, in that the murder was premeditated or planned. The accused must please stand. In the final result, just to sum up, as stated earlier, the accused has already pleaded guilty to count 2, the theft, count 4 and 5, the illegal possession of firearm and ammunition. The accused is therefore convicted on count 2, the theft of the firearm, on count 3, murder read with the provisions of section 51(1) of Act 105 of 1997, count 4, contravention of section 3(1) read with sections 1, 103, 117, 120 and 121 of Act 60 of 2000, and further read with section 250 of Act 51 of 1977. That is to say, an unlawful possession of a firearm. 5, a contravention of section 90, subsection 1, read with sections 1, 103, 117, 120 and 121 of Act 60 of 2000, and further read with section 250 of Act 51 of 1977, unlawful possession of firearm. You end up a clean SAP 69. Thank you. Just give me a moment. Yes, Mr. Mamagodle, are you ready to argue mitigation?
I'm ready, however, my lord, may I just request to get in place for 5 minutes.
You want the matter to stand down?
Yes, of course, please.
Very well. Let me just hear from the state. Have you got any objection?
No objection, my lord.
Can we deal with the other cases now, or what's the position? Should I adjourn first?
The other things, we're still waiting for the accused. Apparently, they are open to question.
Okay.
The reason being, where they are being kept, the police officers around the court, they don't, I don't know, they don't have a working relationship or they don't specification for the last people. Now, they are open.
That is your other case, the so-called farmer. The accused can be seated in the meantime. Is that the farmer, the two accused? Yes. Yes. Can I just adjourn for a few moments, and as soon as that case is ready, just call me so that we can deal with it. The court adjourns for a few minutes.
I use my name